Are you Mr. Rhino? All right, so it appears to the courts that you do not want to come dressed for trial when you're supposed to be dressed for trial. You know.
Mr. Rhino, we had requested some judgments from past hearings we've had and held, and we were provided those today. One of them, and I had received already one. I discussed that with my client. He kind of doesn't like the way I'm approaching everything. He doesn't like the way so he feels that I'm not representing him.
Mr. Rhino, come on down.
So we might want to talk to him because he asked me to get off this. And I told him, that's something you have to discuss. And for the record, we have been related.
This is where a lot of defendants get it wrong. Court-appointed attorneys aren't a customer service line. You don't just swap them out because you don't like the advice. Judges hear this constantly, and to them, it often sounds less like a legal concern and more like a delay tactic.
No.
All right. So, Mr. Rhino. Are you Mr. Rhino? All right. So it appears to the courts that you do not want to come dressed for trial when you're supposed to be dressed for trial.
Believe it or not, but I wasn't aware of this trial. First place.
No, because here's the thing. Firstly, when a deputy at the jail tells you you're supposed to be dressed for trial, you're dressed for trial. And when you're tired, you were told before and you didn't do it. And guess what? If you ever come back to this court where a deputy at the jail has told you to dress for trial and you're not dressed, you know what's going to end up happening? You're going to be going to trial in that red jumpsuit. And you know why you're going to be going to trial in that red jumpsuit? Because it's going to have been your choice. I'm not having you come back to this court again where you're pretending as though nobody told you you had a jury trial. The other thing, you're saying that your attorney is telling me that you want another attorney?
That's correct.
All right, then you need to hire one. Do you understand?
I don't have any support issue. I don't support at all. Right now at the moment.
What support for what?
Coordinate to hire an attorney.
Oh, well then this is your attorney. This is what I've discovered, and I've told many people this before. This is what ends up happening. When you, as a defense attorney, are placed to represent somebody and you've been appointed to represent them, number one, there are certain qualifications that you must have. This is a third-degree felony. It may be bumped up to a second-degree felony based upon what's in the indictment. This attorney would not have been appointed to your case if he didn't have the qualifications to be on this case. I don't allow attorney shopping in this court. Whoever comes up on the wheel, that's who your attorney is. The state will tender an offer to your attorney because I require the state to tender an offer. State can make an offer and say,
This right here is the legal mic drop. Public defenders are assigned based on qualifications, not vibes. If this is a felony, and it is, only attorneys with specific experience even qualify. Translation: the system already checked this lawyer out before the defendant ever met him.
We're offering 20 years. The state can say they're offering the maximum. Guess what? Your attorney has absolutely, really no control over what the state is offering. Even if your attorney were to go to the state and say, well, these are the weaknesses in your case, and this is what my client is willing to accept, the state can still say, I am not going to offer your client what he wants. The only thing I will offer you is A, B, and C. And your attorney, ethically, is obligated to tender that offer to you. Now, you can accept it or not. That's completely up to you. There are certain rights you have when you're charged with the offense. One of them is whether or not you will accept an offer or not.
Here's the part many people don't understand. Defense attorneys don't control plea deals. Prosecutores do. Your lawyer can negotiate, push back, and highlight weaknesses. But at the end of the day, the offer is the offer. The choice to take the risk, that's entirely on the defendant.
And whether or not you will testify at trial and what plea you will enter. Do you understand? So you're not getting another attorney. If you want to hire one, you are more than welcome to hire one. So this is your attorney. Next question.
Why does my case carry prison time? And yet, no.
Here's the thing. You will have to speak to your attorney. What I can tell you is there are certain cases, number one, that you're not eligible for probation. There are certain cases that if you go to a jury trial and if you are found guilty, you're not eligible for probation. There are some cases that if you go to jury trial, maybe you're eligible for probation from a court. But I cannot tell you whether or not, just based upon looking at your case, which would be the indictment for me, whether you're eligible or not. What I can tell you, though, usually if you have a repeater count and you go to a jury trial, you're not eligible for probation. So you need to speak to your attorney about that, and I'm sure your attorney will tell you whether or not you're eligible. Think of criminal history this way. If you have somebody that you loan money to, right? Let's say somebody comes to you and they say, can you loan me $50 and I'll pay you back next week? And you say, yes, I will loan you $50. What are you going to use it for? Oh, I got to pay my electric bill, which that would be a good electric bill these days. And that person gets the $50 and they don't pay you back. And you said you paid me back on this day. You're not paying me back. That person comes to you for a second time and said, look, I'm in dire straits. They're about to cut off my electric bill. I need $60. And you tell them, you know what? I gave you $50 just last week and you never paid it back. And they're like, I know, I'm so sorry for doing that, but I promise you this time I will pay it back and I really need the $60. So you loan them $60 and they don't pay it back. And then they come to you for a third time. You may say, I'm not going to loan you any money. I don't care what your problems is because I've loaned it to you 2 times before and you haven't paid it back. Sometimes people view criminal history that way. And when I was a prosecutor, sometimes people would...
This analogy is gold. Probation is trust. Once you break it twice, judges and prosecutors stop believing promises. It's not personal. It's pattern recognition. And the more chances you burn, the harsher the consequences become.
Do view criminal history that way. They would say, you know what? I gave you probation before, you didn't do well on it, and you pick up another case. I gave you probation the second time, you didn't do well on it, and you pick up another case. So maybe that could be a reason why people make offers that they make. But what I want you to take away from this conversation is this attorney, according to the will, is qualified to handle the type of case that you're charged with. And I would tell you one of the qualifications they must have, and Mr. Gomez, correct me if I'm wrong, he has to have tried cases before, and he has to have tried felony cases before. You can't just have tried misdemeanor cases and then come to felony court and say, oh, I'm qualified. That's not how it works. So he's tried the necessary cases. And if you are upset by the offer that he is tendering to you, no, that is the offer that the state has made. And in this court, I require everybody to treat each other with kindness. So I guarantee you, when the state made him that offer, the state wasn't mean. The state just says, this is the offer I'm making. And I expect you to treat your attorney with respect. I'm sure your attorney will treat you with respect. But again, if you want a different attorney, you need to retain an attorney. So that means you need to go out and hire an attorney. And if you don't have the money to hire an attorney, then this is your attorney. Do you understand? The other thing that's either yes or no. The other thing I need you to understand, and again, we're not doing this anymore. If you are at the jail and they're ordering you dressed for court, that's me ordering you dressed for court because you're up for trial. And I will not have any qualms whatsoever with you going to trial dressed in that red uniform. And you and I both know that red uniform has several meanings attached to it, just the way the orange one does and the blue one does. The blue one for females. Orange, just regular inmates. The red, gang member, age issue, in admin segregation. Yellow with stripes, pregnant, or just yellow, pregnant. Tan or grayish looking color, trustees. So if you want to come to trial dressed in red, that is completely up to you. Do you understand? Do we understand each other? Do you understand the offer that the state has made to you? That's either yes or no.
Yes.
Do you need to confer with your counsel anymore on the offer that the state has made to you? And if you would like to make a counter offer, I'm sure if you would tell your attorney, well, I want to accept this, but this is what I will accept, that's what's called a counter offer. But what that means is you're telling the state, I'm not accepting your offer, I will only accept this. So that means that you're rejecting the state's offer, and it may or may not appear for you again. Do you understand? And I'm sure this attorney will be able to tell you what your range of punishment is in this type of case. I cannot tell you that. I don't know the facts of your case. The only thing I have before me is an indictment. You understand? Do you need to speak with your attorney some more? Do you need to see what evidence the state is saying they have?
Nope.
Have you already seen that?
Not quite yet, but
Mr. Gomez, will you let him see that since we're all here?
I could confer with him. Yeah.
All right, so your attorney's going to confer with you, and the state will let him see their file so you can see their file and see what they have, okay? All right, thank you. 2019 CR 11647, State of Texas versus Jamal Trayvon Coleman. Can I have parties announced for the record for the state? Defense?
Monica Crowell, defense.
And are you Jamal Coleman?
yes, ma'am.
Are you the same Jamal Coleman who was placed on deferred education in 2019 CR 11674 for the offense of aggravated assault with a deadly weapon on November 5th, 2020 for a period of 8 years? Is that you?
Yes, ma'am.
All right, state.
Felony condition number 2 on or about the 7th day of June 2023 in Bull County, Texas. The defendant, Jamal Trayvon Coleman, there failed to submit to a drug test, violation of condition number 2.
How do you plead to that? True or not true?
True. State will weigh them against the other allegations.
All right, did you understand by pleading true to violation of condition number 2? Court can find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there an agreement?
Mr. Honor, the agreement is, Your Honor, choose to follow is to deny the motion and to alter and amend his conditions of probation to include the ISF dual track, and to complete the dual tracking.
All right, is that the agreement?
It is, Judge.
All right, Mr. Coleman, raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hands, state your name for the record.
Jamal Trayvon Coleman.
All right, Mr. Coleman, do you want to go to prison? Then why do you keep coming before me with violations?
I'm on issue with drugs.
This is the moment where courtroom frustration turns into concern. The judge isn't just asking a question, she's testing accountability. At this stage, the system is offering help one last time. The next stop, if this fails, isn't probation, it's prison.